Good morning. I hope everyone's doing great, enjoying this crazy February weather we're having. Crazy good. So today we have several cases on the docket, but only one is scheduled to argue. So I'm going to call out the docket for today, which is Tuesday, February 27. So the first case we have on the docket is the one that we'll be arguing, which is case number C230412, State of Ohio versus Palmer. If attorneys can please identify themselves and their readiness to proceed.
Yes, good morning, Your Honor. Mr. Easy on behalf of Ms. Palmer, ready to proceed.
Good morning.
Corey Gooder on behalf of the City of Cincinnati, ready to proceed.
Good morning.
Good morning.
And then we have four more cases that have all submitted on the briefs. Case number C230192 and 193, which is Elkins versus Durrani. Case number 230188189, which is Draft, and I'm sure I pronounced that wrong, versus Durrani. Case number C230190191, which is Dumas versus Durrani. And case number C230453454, which is State of Ohio versus Stephen Stroud. All right, so we're going to start and end with State of Ohio versus Palmer. Good morning.
Good morning again, Your Honors.
Would you like to give me a second? I need to
Sure.
set my timer here. Give me a second. All righty, we're good to go. Would you like to reserve time?
Yes, I'd like to reserve 3 minutes, please. Thank
All
you.
right, whenever you're ready, you can get started.
May it please the Court, Ms. Gooder. This case presents this Court with another opportunity to address whether the Ohio Constitution affords greater rights than the federal Constitution. Specifically, Ms. Palmer urges this Court to rule that the right of confrontation should be afforded a criminal defendant at a contested restitution hearing. Alternatively, should this Court wish to avoid the constitutional issue, it can find that the restitution award in this case constituted an abuse of discretion within the statutory framework.
Can you start there?
The second assignment of
Yeah.
error? Sure
On-
can.
On that,
Yeah,
yeah, on that
Sure
issue.
can. So it is our position that, as you know, I won't spend a lot of time reviewing the law, but the victim bears the burden of establishing the amount of restitution. The quantum of proof is a preponderance, and they have to present competent, credible evidence from which the trial court can discern the restitution award to a reasonable degree of certainty. So neither the purported Blue Book printout nor the unsupported mechanic estimate, we believe at least, did not constitute competent, credible evidence.
Well,
And here's
didn't
why.
the trial court ground its finding as to the value of the car strictly in the Blue Book or the purported Blue Book printout?
They did, but our contention is that that was not sufficient because the Blue Book document itself, as you know, that there has to be some indicia of reliability, and there's no, it's kind of an odd printout. There's no header saying where it's from. There's no footer saying a website. We don't know. Blue Book, as you probably know, values cars based upon 4 conditions. I believe it is, I have it written down, fair, good, very good, or excellent. We don't know what that $3,200 amount was based upon.
Do we even know what car this
We
was?
don't. So I was getting to that. We don't know the make, model, anything of the car that was inputted to get that amount. So I believe all we can see is one amount, and then on the bottom is a mileage, and then a zip code.
Do we know where the Blue Book printout came from? I know it was proffered by the prosecution, but do we know if the prosecutor printed this out or if the victim did or someone else?
My mental note is that, actually, I'm not positive about that. And I can look back, when Ms. Gooder is up, I can look through my notes and try to find out. But I'm not certain. My mental note is I thought the victim conveyed those, but I'm not sure. Actually, I'm not sure.
So I know in cases like this, Blue Book printouts are often used, and you're not arguing that a Blue Book printout would never be sufficient,
Correct.
are you?
Yes.
So what would make a Blue Book printout sufficient without a victim's testimony?
There, yes. I would think if we can at least see an indicia, maybe some kind of It doesn't even say Blue Book, Kelly Blue Book on this. So some kind of official seal, a footer, you know, footers often show the website address, the web address, so I assume it's like kbb.com or something like that. If it had an indicia of where it came from, and then what was inputted, what kind of car was inputted to get that, what the search parameters were to get this value. I would think that would be enough without the person being there to testify.
But because this doesn't have any of that, your argument is that the person should have been there who printed it out to explain what that is?
Sort of. Our argument is that, you know, I'm hesitant to say that a right of confrontation is going to always attach at restitution. This is where the two assignments very kind of dovetail a little bit, so I won't spend a lot of time. But where evidence is elicited and there's a fact-finding function. That is one of the reasons in capital cases why there is a confrontation right at the penalty phase. Is there's a fact-finding function when restitution is contested and then evidence, testimony, documents are elicited to fact-find these amounts. I would say the best practice is always to have the victim there. And I said that the tension between Marcy's law, you can tell I'm chomping at the bit to get to the first assignment of error, but the tension that's there, it's a better practice, and that if it's contested and there's fact-finding that must be done, we would say regardless of the exhibits presented, the victim should be there.
And what would have been the fact-finding here?
So it would be, here the amount, because it's contested, and just the precise amount. It's a fact-finding function in a contested hearing. Like if the person comes and oftentimes restitution is going to be agreed upon, but there's some nuances they want to argue about, that might not entail as much fact-finding. And off the top of my head, a car is an easy one because there's a specific valuation based upon a number of factors.
Right.
That's going to go into what that car was worth at the time of the collision.
Right. So if the Blue Book, if the information on the value of the vehicle were more robust than
Yes.
what was submitted, would that have sufficed?
I think it would have. You know, we're injecting a novel issue onto that, grafting it onto that. But if we're just looking at the second assignment of error in the statutory framework, I think if you had some of this missing info given, it would have been sufficient to determine if that's the value of the car before the accident.
So then how is the testimony of the victim necessary? Because it seems to me that that's what you're saying, that, okay, you're not looking for a blanket rule, but you're basically saying the circumstances of this case,
Yeah.
right?
Right.
So how is it that it was necessary in order to get that from the victim, as opposed to it being properly submitted through an evaluation by the state?
Sure. So this case does present an example of circumstances where the contested nature does require the victim to come in. And the basis for that in this case is it was only presented through counsel and not developed, so there was no evidentiary testimony. But there was a contention on the record that the car was still in drivable condition. So there was a contested factor around the condition of the car, and that informed what the evaluation should be. And there was, again, it wasn't developed and admitted because counsel didn't want to go forward without the victim. But there was purported to be video of the car being driven, and that affects the value. It's not totaled, in other words, and that would have been developed by questioning the victim about that.
Okay, so I'm trying to understand this. When you say it's not total, how are you looking at total? What does that mean?
The trial counsel tried to develop that the value of the car, the restitution amount should have been reduced because the car was not a total loss. So when the damage exceeds the value, so in this case, and we're not conceding that the repair estimate was supported adequately either, but regardless, it was well above that Blue Book value.
Well, counsel, could I interject there?
Sure.
So didn't the trial court have to make a finding there? Because the high end of the range on the printout that we'll just say for purposes of argument that it's from Kelly Blue Book, it's $3,925.
Right.
But the estimate for the repairs was $3,800.
Right.
So there is a range at the high end of the Blue Book printout at which the car would not have been a total
Right, and I
loss.
think that was, yes, sorry.
So the trial court had to make some implicit findings in order to get to having this car be totaled, one of which was that the high end of the Kelly Blue Book range was not appropriate.
Yes, and I think that, like you said, it's kind of implicit. And I think under this court's prior case law, and I want to say it might be the Miles case, but there have been a few cases over the past few years we're finding restitution out of this court. And I want to say that one of those was a vehicular, a collision, and there was a question, it was reversed on whether the trial court made an appropriate finding as to that, did the repair value exceed the value of the car? They made explicit findings, or were they were supposed to. And in the absence of doing that, I think it can't be implicit, that they have to make that finding. And so that's why the remedy we're actually asking for here is a new hearing, not to just vacate restitution and be done with it.
Was there any evidence in the record to support the trial court's implicit finding that restitution between the amount of $3,800 and $3,925 would not have been appropriate?
Not really, and I would say the record actually kind of supports the opposite, because this was continued a number of times. And at one of the points, the state had already presented these two exhibits, the purported Blue Book and the estimate. And the court said, I'm not going to go forward on this evidence, implying that it wasn't enough and we need more. So the court didn't hold the hearing that day. They said, we're going to continue it. And I read into that, further developing the record, and then nothing new was presented.
And wasn't there a discussion at that hearing about those exhibits not being properly authenticated in the absence of a witness?
I believe so. So I think that was another reason it was continued, with the idea that we need to get more. And then
Does
for
the
whatever,
rules of evidence apply in a restitution hearing?
the rules of evidence don't. No, but because the standard is competent, credible evidence, there is a credibility determination that has to be made. Otherwise people can come in and throw anything, and, it has to be something from which the court can make that determination under the statutes.
At what point, as I went through the hearings, wasn't there a moment where the victim had conceded that that the defendant had conceded that the victim was not needed for the restitution hearing?
I don't recall that. I actually thought the opposite, that counsel even went to the trouble of subpoenaing the witness twice, and vocally not wanting to go forward without the witness present. I think she made that a point.
I think that's later, but in one of the earlier hearings, but that's okay.
I don't recall that. Maybe my mind glossed
Yeah.
over, but I don't recall her.
It's all
yeah,
right.
making that.
I want to go back to the concept of the vehicle being drivable and the connection between that and the vehicle being totaled, okay? Am I reading the record correctly that it was the victim who had made a statement that the vehicle was totaled?
I think that was the prosecution. The victim never came, so I think that was the prosecution that was making a claim that the victim was the vehicle was a total loss.
So it was the prosecution then
I believe so.
bringing
Maybe
forward that this is what the victim had told me?
I believe
Okay.
so. Maybe
Thank
Ms.
you.
Gooder can correct me if I have a misapprehension.
No,
but-
it's okay. It's
Yeah, because
all
I
right.
know the victim never came, so,
Yeah.
yeah.
Understood. Thank you. How is drivability connected to it being totaled?
So I think I think trial counsel's idea behind that is that if the vehicle, number one, that would reflect on the condition and the valuation that the restitution award is going to be based on condition. And then that was a kind of a mitigative, if that's a word, mitigating factor, that if the vehicle's, on the front lawn, can't ever be driven again, perhaps it was a higher amount, but if it's not a total loss, then that was a mitigating factor.
But
So I
doesn't-
think that's what they were getting to.
So, but ultimately, it seems to me that it's all about what is the value, economic loss, the value of the vehicle prior to the moment of the collision,
Right,
right?
right.
And so if the value was less than what it takes to repair it, right?
Right.
Then that's the whole total thing. But at the end of the day, I guess it goes back to my initial question about, it's by presenting a more robust presentation of the value of the vehicle before, whether that would be sufficient. And I'm still trying to understand then, if that would have been sufficient, then how is the victim necessary?
part of that is because the
And I'm talking about in
evidence-
this case, you know, so
Yeah.
without getting into, perhaps there, you know, there might be a case in which it's necessary for the victim to come in.
Right.
You know, whether, you know, how is it that this is one of those cases?
Right. So we have, well, I think the mental roadblock we have to get past is this 3,200, what was it? This range, even this whole range here, we don't even know if that range is appropriate.
Right,
You
right.
know what I mean? That's our mental, for now, our basement number, and because of the evidence of that valuation had no real indicia of credibility, we can't even determine our baseline. So to even view that estimate against, we don't have a proper baseline to even try to view the mechanic's estimate against.
But isn't a mechanic better situated to determine those things than an owner?
I would
Because
say
now we're relying on an owner that would know a bit about vehicles.
not really. So a vehicle, for one thing, I think fair market value and what, you know, anyone who's like gone to a dealership to get a repair versus their local mom and pop shop, the repair estimates are vary widely depending upon what neighborhood they're in even, you know, there's
Yeah,
going to
I
be
agree.
huge,
Yeah, I understand what you're saying.
huge
Yes.
swings in the
Yeah,
estimate, right?
right, like it's going to be varying on the part of the country and all that stuff.
Right.
Right.
So, and then
That's
also.
why some people travel to get their cars and then bring it back.
True, and the fair market value of selling cars, gosh, even in the past few years with the economy has really swung. So possibly if they go, that's funny, if they go back to a restitution hearing now and type in Blue Book, it could be higher. I guess that's the risk we run. So on both ends, both the valuation and the repair estimates, I think there's just such variability that is another reason why we you know, ideally, trial counsel would subpoena a mechanic as well, and maybe that's a can of worms you don't want to open. Maybe it's strategic, I don't know. But I think on both ends of the valuation, we can have huge swings. So it's just more ideal to have the people there.
Well, and isn't a defendant fully reliant upon the state to bring forward these witnesses? I mean, the defendant isn't in possession of the victim's car and have access to this kind of information themselves.
They are, and the defense is at the mercy of at most, the subpoena process. So, I mean, I guess she's not going to move for contempt because the witness didn't show here twice, and that's the most that the defense can do to marshal the evidence because it's not within their control. It's not within their purview. Yeah.
So unless there's any other questions.
Okay.
All right.
I'll reserve the remainder.
Yeah,
Thank
yeah,
you.
I will reserve the remainder for you.
Thank you.
No worries at all.
Good morning, Your
Good
Honors.
morning, good to see you.
Good to see you all.
Long time no see.
I know, a couple years. Tori Gooder on behalf of the City of Cincinnati. May it please the court. I'll start with answering a couple of the questions I heard from you all. Specifically, I wanted to start with the burden here. I think actually the statute's changed. It originally was the victim in 2021. However, the statute in effect at the time of this hearing kind of got rid of that language that put it on the victim to provide the restitution amount. And instead, it changed it to just saying the court shall determine the amount of full restitution by a preponderance of the evidence. So I do think there's kind of a question here of, really, it's not the victim's burden in this case. And moving to who provided the Kelly Blue Book.
I agree with you, but it is the victim's, but at the end of the day, is it, I guess one can say perhaps it's the victim's right to restitution?
I do think-
Restitution's going to flow to the victim, right?
Absolutely, through Marcy's
Yeah.
law, absolutely. And they do in the statute have an opportunity to provide information. The statute allows for the defendant to provide info,
Right.
the state to provide info, the victim to provide info.
Right.
And that is what happened here. The victim had provided both the estimate to the prosecution and the Kelly Blue Book amount. And the cite to that is on the May 30th hearing on page 2, if the court needs that. I also think there's an issue as to whether this really was a contested restitution amount. The amount in question that was shown on the Kelly Blue Book or on the mechanic's estimate wasn't necessarily being challenged by the defense here. If you look at the
Well,
record.
didn't the defendant, is that a fair characterization of the record? I mean, the defendant objected to both exhibits, and at each and every hearing, the defendant was contesting something about this restitution.
I do agree that contesting something about the restitution, in the beginning, at the first hearing, it was wanting a receipt for the damages, which the state then provided. And then it was about whether the insurance claim had already been covered so that there wasn't a windfall. And the state provided information as to that, which was that an insurance claim wasn't filed in this case because defendant didn't have insurance, and then the victim's was only liability. So it was only if she was at fault was she covered. And then that third hearing is when starts objecting to the restitution, but specifically the defense kind of limits it to the operability of the vehicle, and that the court couldn't impose the repairment amount, that lower amount. And I think that's showing that it's contesting what the court could do, not necessarily the amount. At no point did defendant bring in a different Kelley Blue Book amount and say, this is against what the state's providing. Never did they ask for a mechanic to evaluate the vehicle. I do understand the hardship you guys were all speaking to, meaning that, you know, it's.
And I understand what you're saying, but going back to where you started.
Yeah.
It was the state's burden, right? So it kind of becomes a question of, did the state meet their burden of establishing what the economic loss was?
So I think so. I think that they provided the two exhibits that provided from a mechanic the court ordered to evaluate the vehicle at the plea hearing. That mechanic looked at the car and provided the damages, and then the victim followed through with providing a Kelley Blue Book amount based on the mileage prior to the accident, and that was put forth. At no time did the defendant object to that wasn't a reflection of the car that was damaged or anything like that. We don't have any.
What about the Kelley Blue Book? Because that was a little strange, wouldn't you admit? Like,
It was a little strange.
from what I think we've all seen with Kelley Blue Book, I mean, do you think that just that piece of paper was good enough in this case?
I do think it was good enough in this case, and I think that's shown by defense counsel never raising that particular issue, that the Kelley Blue Book was a different car or wasn't reflecting the mileage correctly or anything like that. There were no challenges to the specific showing on the Kelley Blue Book. It was just that it didn't have a heading or whatnot. But
Isn't that a challenge, though, saying that that's not a good enough example of what this car's worth is pursuant to the Blue Book website, because it doesn't even have the website on it?
it does feel like an authenticity argument.
Yeah.
I would say that the evidence rule don't apply in restitution hearings, but I do understand the argument that it wasn't reliable.
The due process applies.
Yes.
And I think if there's a dispute about the evidence, then the defense should have some opportunity to challenge that. And it sounds like the appellant is conceding that if it were a different type of Blue Book printout, it might have been okay. But this particular printout might have needed maybe witness testimony to go along with it.
And I think that if it did need witness testimony, I don't think that would have been to the victim. Kind of to Judge Dias's point, I think the argument that the victim needed to be there is a little bit of a red herring in this case. The victim had, and the defense knew about this at the plea hearing, had medical conditions, and there was kind of an agreement that we were trying not to bring her back here because she was prone to seizures and actually was having trouble at the plea hearing going through with everything. And so we were trying to resolve the restitution issue kind of ahead of time. And
I didn't say necessarily the victim. I just said something more. If they're challenging the authenticity of that exhibit, it sounds to me like there should have been something more to go along with it at somebody's testimony.
Do we even know where it came from? Do we know if the prosecution created the Blue Book printout, or if the victim did, or someone else?
yes, it was the victim. And on page 2 of the May 30th hearing, we note that they had provided both the estimate and then the Kelley Blue Book printout. So it was from the victim.
So if we were looking for information about inputs, so what car was put in, what condition, what mileage, et cetera, that information would have come from the victim. The victim would be the source of that.
I think so, but again, I don't think the defendant really raised that part of the issue. They didn't ask for the victim to be there for that reason. The first time they said the victim needed to be there was because they believed they had a video of the victim driving the car around, and so they believed the operability was an issue. And then the second time was the confrontation argument that came up. So never was it about what mileage was put in, what type of car was put in. Defense never raised that below.
Which brings the interesting issue of total and the drivability to total. Do you believe there's a connection there, and what would that be?
So I don't think so. To my understanding, under this court's precedent, the standard is the court needs to determine the actual value of the vehicle, and a lot of the times it's going to do that by hearing what repairs need to be made, what the mechanic says. That can be, if it's totaled, the repairs might be too much that it exceeds the worth of the vehicle. But there's also going to be times where the vehicle is just so old that the repairs might just be too much, even though the car's still drivable. I think it's going to change based on the facts of each case, and really the standard will come back to what this court's already state, which is the court needs to decide the actual value of the vehicle, and if the repairs exceed that, then it needs to impose the actual value of the vehicle and not more than that.
Let me ask you this, because there's a discussion about the authenticity of this alleged Blue Book valuation. Is it an issue of authenticity, or is it an issue of reliability? Of the reliability of that document for the determination of the value of the vehicle?
It seems to me more an authenticity issue in the defense's eyes with talking about the header.
But from your perspective?
From my perspective, I think it's more of a reliability issue, but again, I don't think defense raised that here and wasn't saying the victim was unreliable in putting in that information.
Well, not the victim, I'm talking about the
actual
valuation
valuation.
itself. You know, that I think it seems like both of you agree that it was lacking some information.
Yeah.
So is the lack, are those deficiencies, you know, because rules of evidence don't apply, does it go to authentication, or does it go to the reliability of that document in determining the value of the vehicle?
In my perspective, I think that what would have made this Blue Book better would have been if you had been able to see the header maybe a little bit more clearly and seen the vehicle information that was put in. But I don't think that makes the Kelley Blue Book unreliable. I think that it had the mileage that was told to defense, that was the vehicle's mileage prior to the incident, something that was actually talked about between the prosecution and defense prior to that. It also had the date it was valid, and it had at the bottom that it was in good condition. So I think that it goes to, that lack of header would go to the authenticity of the document, which doesn't apply at a restitution hearing, and makes sense why it doesn't, because at a restitution hearing, and especially in municipal court, sometimes there's a lot moving and a lot of documents being brought in, and sometimes things get cut off, and it just happens that way. But it's not that it's not a reliable document, it's just that it maybe is not as authentic as it could be because it doesn't have a header or the extra.
This document, even if we accept that it's reliable, the document sets forth a range of $2,549 to $3,925. The trial court chose $3,233, which was designated as the private party value, and not, for example, $2,549, which is the lowest end. Do we know why the trial court picked that $3,233 number, and is there any evidence in the record to justify that selection?
I don't think that the trial court was super explicit as to picking that evaluation. I think it's implicit that the reason he did that was because, and a lot of Kelley Blue Books give that wide range, but the private party sale, if that car was sold then and there, would be that $3,233. And I think the court found that that's the most reliable value of the car, because that's what it would sell to a private party for.
And isn't there an issue also with this date range? I mean, as I recall, this the Blue Book printout was from April, I think, or maybe July, and then the accident was many months before that.
So it was valid I think it was April 7th or right before that hearing, but my understanding was the mileage that was plugged in was based on what the mileage was prior to the accident.
And do you know, I do not know the answer to this, so I'm just throwing it out there. Can you manipulate the dates on Kelley Blue Book? Can you go backwards?
I'm not sure. I don't actually have personal experience, and I haven't tried it. Maybe it's something I need to do, as I've seen many Kelley Blue Books brought to the court, so I do not have an answer to that, however.
Thank you.
And I understand that your position is that the state did meet their burden, okay? Just as a hypothetical,
Yes.
if the state had not met their burden, what would you say is the correct remedy in this case?
Your Honor, I would say the correct remedy at this point, if the state hasn't met its burden, would be to reverse and provide a new restitution hearing. I don't think it would just be to vacate the restitution order and then have no restitution imposed. I think it would be that the court didn't find by a preponderance of the evidence and that it needed to go back for an evidentiary hearing to be provided to the state to do such, especially with how kind of procedurally odd this case was, with the kind of constant continuances, almost never clear of whether witnesses were supposed to be coming in and testifying. The mechanics weren't subpoenaed by either parties. There's kind of some confusion of what kind of hearing we're doing. So I think that that would probably be the remedy in
Okay,
this case.
because you do concede that the victim, in essence, requested the restitution hearing.
I don't know if I can see that the victim asked for the restitution hearing. At the plea hearing, what kind of happened to me from the record was that the victim was there and there had been an amount thrown out of $4,000 roughly. And then the defense counsel, understandably said, well, I need some documentation as to that. And so then it was set out for restitution hearing. I don't think the victim really was the one that's requesting that. It almost seemed more like the state offered it and defense wanted that concrete receipt, and then the court set it for a restitution hearing.
So if there were a remand for a restitution hearing, again, I'm going to use the word hypothetical
Yes.
because I understand where your position, okay? If it were remanded for a restitution hearing, is the victim necessary to that restitution hearing in order to determine the value of the vehicle prior to the collision?
I don't think the victim's necessary. I think that if the defense wants to argue they need a better Kelley Blue Book printout, that could be provided. I still don't think the victim needs to come if that Blue Book is sufficient to the defense to show what car is being evaluated and the price and mileage and everything like that to it. I think more what it sounds like defense was wanting was to have the mechanic there to understand why the damages were being evaluated that way, and then someone to testify as to why the Kelley Blue Book amount was at that value. Again, I don't know, and I haven't heard of a situation where an expert comes in for a Kelley Blue Book evaluation. I'm not sure who quite testifies to that.
Yeah, understood.
But I'm sure a mechanic could speak to what's considered.
So let me ask you this. Again, in this hypothetical world that we're in right now, okay, it gets remanded, right? Let's say that we all agree that the victim is not necessary, and the state presents a similarly situated representation of the valuation, right? Wouldn't it be within the authority of the trial court to say, state, you have not met your burden and no restitution will be ordered?
Asking if the court has the right to do that? I think so. I mean, the court in the statute clearly said they have to find it by preponderance of the evidence,
Yeah.
that it's competent, credible evidence.
So going back to the burden, it almost feels like by saying that the victim must be, that now we're kind of shifting that burden. And so if the state doesn't meet the burden, the trial court would just say, hey, no restitution.
Yes. Yeah, I don't think it should shift to the victim. And I think that's kind of the point of that change in the restitution's language. The restitution statute language was kind of showing they have a right to restitution, but it's not on the victim to prove. They can give information. The statute provides for that. The state can provide information. The defendant can provide information. But at the end of the day, it's to the court to decide by a preponderance of the evidence what's going to be happening. And so I don't think that should be shifting to the victim by any means.
I don't know if there's any other questions. And let me see. If there's anything else you want to close with, I'll definitely.
I'm not sure of my
take it.
time, but I'll just wrap up with.
That's what I'm saying, I'll get you.
Yes, thank you. I would just ask you to overrule both assignments of error. Just briefly as to the confrontation clause issue, I don't think this should go beyond a trial setting, and I think the Ohio Constitution's language actually even more limits the right to confront to a trial setting by using the word trial twice, contrary to the federal Constitution, and in addition, continually using the word accused where when we're at a restitution hearing, you can tell they start using the word offender. The guilty finding has already been set, and now we're at a position where we're just trying to figure out amounts, not trying to figure out who was accused of the crime. That's already been decided. I'd ask you to affirm the trial court's restitution order.
Thank you.
Okay. Just wanted to hit a few points. The statute being amended and burden shifting, that argument, as well as the nature of the contested restitution amount, I forget the exact argument now, it doesn't matter. Those, the state's brief did not raise that whole statutory argument. So if this court wants to ground its decision in that in any way, I would be asked out of fairness to be allowed to brief that. So I would have a chance to respond to that and research it. You know, I need to look at Lexis and do some statutory delving to answer that properly.
You're talking about the change in the statute?
Right, right. The state's brief, I know there was a change in counsel below, or here, I'm sorry. But the state's brief was limited to, this is the statutory scheme, the statute allows this at the end. So I have not had a chance to respond to that
So
argument
you
yet.
didn't make your arguments under the statute that was in place at the time of the restitution hearing? 'Cause
I'm not
that's
sure.
what they're saying, they're just looking at the statute that was in
Yeah, I
place.
don't, like, the way that the language has changed, I have a feeling, based upon just my general knowledge of the legislature, that the statute was probably changed to conform to a nuance that maybe the parties were misconstruing or something, not to place the burden on the defense. I have a feeling that was not the intent. The legislature was already probably trying to refine something that they meant in the first place.
I don't think that they argued that the burden was on the defense. The burden is still on the state, but it's,
Saying it's not on the victim at all, and that, that's what I was hearing implicitly, that even the defense needs to come present things possibly, or I know that they can.
that evidence is presented to the judge, and then the judge determines whether or not there's
Right.
sufficient evidence to
Right,
order restitution.
right.
Right.
But I suspect that the legislation was probably brought in line with original legislative intent, because that's usually what happens in these cases, but I don't know, I'd need to research that. If, I would argue that the record does support that restitution was disputed, as this court has said before in Miles and other cases, that the trial court must hold a hearing if restitution is disputed, so that is why we went forward with the hearing here. The argument that certain arguments were not raised in particular, I think that it just needs to be contested, and it clearly was. And then the whole, agreed that the rules of evidence don't apply to restitution hearings. But again, the standard is competent, credible evidence. And that is really, I don't want to get mired down in authentication, that is a trial term. Really, it's the competent, credible nature of the evidence is the statutory language I would like to focus on. And then, Judge Kinsley, your question led me to down an interesting road over at council table. So you had asked if the date could be manipulated on Kelley Blue Book, and it cannot. So that's going to be a problem on remand and even here, because when you input everything, as I just did, it's for today's date. So there's no option to redo it. This, it says on this exhibit, was the value as of 4/7/23. The accident was in July of the prior year. And as we discussed, with the way the economy has gone, used vehicles are actually a hot commodity. So if anything, the value may have gone up in that period. And the law requires it to be the value at the time of the collision or immediately before the collision.
So you can never use Kelley Blue Book in a restitution hearing?
It's going to be difficult because that is the law. It has to be right at the time. Maybe someone more technologically advanced than I can manipulate the date somehow, but I did not see a way to. That's going to be a problem because it is the snapshot. What is the value right then? And even this is a value, more than 6 months later?
So for people in accidents, it's going to be critical to document contemporaneous with the accident.
Yes, that would be.
Because our
best
case
practice.
law directs
That-
us to that period
The
of time.
snapshot, right. So the Kelley Blue Book might be a problem for future practitioners. And then we agree on the remedy. You know, I don't agree that, I'm not asking this court just to vacate it and be done with it. New hearing, and then if the court doesn't find the evidence competent, credible, like you said, Judge, that burden not met, but that's not, that's for afterward. We'll find out. That's the only points I had. If there are no further questions, we would just ask the court to reverse and remand for a new restitution hearing.
All
Okay,
right,
thank
thank you
you.
so much. Thank you both for your arguments this morning. Great to see you both. I hope you both have a wonderful afternoon and a great week, and maybe the weather will continue to provide such loveliness for all of us. So that concludes our hearing for today. Thank you so much. Yes. And we will take the matter into submission and issue timely decision.